The United Nations Convention on the Law of the Sea of 1992. Part 5. Exclusive Economic Zone. Article 55. Specific legal regime of the Exclusive Economic Zone. The Exclusive Economic Zone is an area beyond and adjacent to the territorial sea, subject to the specific legal regime established in this part, under which the rights and jurisdiction of the coastal state and the rights and freedoms of other states are governed by the relevant provisions of this convention. Article 56. Rights, jurisdiction and duties of the coastal state in the Exclusive Economic Zone. 1. In the Exclusive Economic Zone, the coastal state has a. Sovereign rights for the purpose of exploring and exploiting, conserving and managing the natural resources, whether living or non-living, of the waters superjacent to the seabed and of the seabed and its subsoil, and with regard to other activities for the economic exploitation and exploration of the zone, such as the production of energy from the water, currents and winds. b. Jurisdiction as provided for in the relevant provisions of this convention with regard to I. The establishment and use of artificial islands, installations and structures. 2. Marine scientific research. 3. The protection and preservation of the marine environment. c. Other rights and duties provided for in this convention. 2. In exercising its rights and performing its duties under this convention in the Exclusive Economic Zone, the coastal state shall have due regard to the rights and duties of other states and shall act in a manner compatible with the provisions of this convention. 3. The rights set out in this article with respect to the seabed and subsoil shall be exercised in accordance with Part 6. Article 57. Breadth of the Exclusive Economic Zone. The Exclusive Economic Zone shall not extend beyond 200 nautical miles from the baselines from which the breadth of the territorial sea is measured. Article 58. Rights and duties of other states in the Exclusive Economic Zone. 1. In the Exclusive Economic Zone, all states, whether coastal or landlocked, enjoy, subject to the relevant provisions of this convention, the freedoms referred to in Article 87 of navigation and overflight and of the laying of submarine cables and pipelines, and other internationally lawful uses of the sea related to these freedoms, such as those associated with the operation of ships, aircraft and submarine cables and pipelines, and compatible with the other provisions of this convention. 2. Articles 88 to 115 and other pertinent rules of international law apply to the Exclusive Economic Zone insofar as they are not incompatible with this part. 3. In exercising their rights and performing their duties under this convention in the Exclusive Economic Zone, states shall have due regard to the rights and duties of the coastal state and shall comply with the laws and regulations adopted by the coastal state in accordance with the provisions of this convention and other rules of international law insofar as they are not incompatible with this part. Article 59. Basis for the resolution of conflicts. Regarding the attribution of rights and jurisdiction in the Exclusive Economic Zone. In cases where this convention does not attribute rights or jurisdiction to the coastal state or to other states within the Exclusive Economic Zone, and a conflict arises between the interests of the coastal state and any other state or states, the conflict should be resolved on the basis of equity and in the light of all the relevant circumstances, taking into account the respective importance of the interests involved to the parties as well as to the international community as a whole. Article 60. Artificial islands, installations and structures. In the Exclusive Economic Zone. 1. In the Exclusive Economic Zone, the coastal state shall have the exclusive right to construct and to authorize and regulate the construction, operation and use of a. Artificial islands. b. Installations and structures for the purposes provided for in Article 56 and other economic purposes. c. Installations and structures which may interfere with the exercise of the rights of the coastal state in the zone. 2. The coastal state shall have exclusive jurisdiction over such artificial islands, installations and structures, including jurisdiction with regard to customs, fiscal, health, safety and immigration laws and regulations. 3. Due notice must be given of the construction of such artificial islands, installations or structures, and permanent means for giving warning of their presence must be maintained. Any installations or structures which are abandoned or disused shall be removed to ensure safety of navigation, taking into account any generally accepted international standards established in this regard by the competent international organization. Such removal shall also have due regard to fishing, the protection of the marine environment and the rights and duties of other states. Appropriate publicity shall be given to the depth, position and dimensions of any installations or structures not entirely removed. 4. The coastal state may, where necessary, establish reasonable safety zones around such artificial islands, installations and structures in which it may take appropriate measures to ensure the safety both of navigation and of the artificial islands, installations and structures. 5. The breadth of the safety zone shall be determined by the coastal state, taking into account applicable international standards. Such zones shall be designed to ensure that they are reasonably related to the nature and function of the artificial islands, installations or structures, and shall not exceed a distance of 500 meters around them, measured from each point of their outer edge, except as authorized by generally accepted international standards or as recommended by the competent international organization. Due notice shall be given of the extent of safety zones. 6. All ships must respect these safety zones and shall comply with generally accepted international standards regarding navigation in the vicinity of artificial islands, installations, structures and safety zones. 7. Artificial islands, installations and structures and the safety zones around them may not be established where interference may be caused to the use of recognized sea lanes essential to international navigation. 8. Artificial islands, installations and structures do not possess the status of islands. They have no territorial sea of their own, and their presence does not affect the delimitation of the territorial sea, the exclusive economic zone or the continental shelf. Article 61. Conservation of the living resources. 1. The coastal state shall determine the allowable catch of the living resources in its exclusive economic zone. 2. The coastal state, taking into account the best scientific evidence available to it, shall ensure through proper conservation and management measures that the maintenance of the living resources in the exclusive economic zone is not endangered by overexploitation. As appropriate, the coastal state and competent international organizations, whether subregional, regional or global, shall cooperate to this end. 3. Such measures shall also be designed to maintain or restore populations of harvested species at levels which can produce the maximum sustainable yield, as qualified by relevant environmental and economic factors, including the economic needs of coastal fishing communities and the special requirements of developing states, and taking into account fishing patterns, the interdependence of stocks and any generally recommended international minimum standards, whether subregional, regional or global. 4. In taking such measures the coastal state shall take into consideration the effects on species associated with or dependent upon harvested species with a view to maintaining or restoring populations of such associated or dependent species above levels at which their reproduction may become seriously threatened. 5. Available scientific information, catch and fishing effort statistics, and other data relevant to the conservation of fish stocks shall be contributed and exchanged on a regular basis through competent international organizations, whether subregional, regional or global, where appropriate and with participation by all states concerned, including states whose nationals are allowed to fish in the exclusive economic zone. Article 62. Utilization of the living resources. 1. The coastal state shall promote the objective of optimum utilization of the living resources in the exclusive economic zone without prejudice to Article 61. 2. The coastal state shall determine its capacity to harvest the living resources of the exclusive economic zone. Where the coastal state does not have the capacity to harvest the entire allowable catch, it shall, through agreements or other arrangements and pursuant to the terms, conditions, laws and regulations referred to in paragraph 4, give other states access to the surplus of the allowable catch, having particular regard to the provisions of Articles 69 and 70, especially in relation to the developing states mentioned therein. 3. In giving access to other states to its exclusive economic zone under this article, the coastal state shall take into account all relevant factors, including, inter alia, the significance of the living resources of the area to the economy of the coastal state concerned and its other national interests, the provisions of Articles 69 and 70, the requirements of developing states in the subregion or region in harvesting part of the surplus and the need to minimize economic dislocation in states whose nationals have habitually fished in the zone or which have made substantial efforts in research and identification of stocks. 4. Nationals of other states fishing in the exclusive economic zone shall comply with the conservation measures and with the other terms and conditions established in the laws and regulations of the coastal state. These laws and regulations shall be consistent with this convention and may relate, inter alia, to the following. A. Licensing of fishermen, fishing vessels and equipment, including payment of fees and other forms of remuneration, which, in the case of developing coastal states, may consist of adequate compensation in the field of financing, equipment and technology relating to the fishing industry. B. Determining the species which may be caught, and fixing quotas of catch, whether in relation to particular stocks or groups of stocks or catch per vessel over a period of time or to the catch by nationals of any state during a specified period. C. Regulating seasons and areas of fishing, the types, sizes and amount of gear, and the types, sizes and number of fishing vessels that may be used. D. Fixing the agent size of fish and other species that may be caught. E. Specifying information required of fishing vessels, including catch and effort statistics and vessel position reports. F. Requiring, under the authorization and control of the coastal state, the conduct of specified fisheries research programs and regulating the conduct of such research, including the sampling of catches, disposition of samples and reporting of associated scientific data. G. The placing of observers or trainees on board such vessels by the coastal state. H. The landing of all or any part of the catch by such vessels in the ports of the coastal state. I. Terms and conditions relating to joint ventures or other cooperative arrangements. J. Requirements for the training of personnel and the transfer of fisheries technology, including enhancement of the coastal state's capability of undertaking fisheries research. K. Enforcement procedures. 5. Coastal states shall give due notice of conservation and management laws and regulations. Article 63. Stocks occurring within the exclusive economic zones of two or more coastal states or both within the exclusive economic zone, and in an area beyond and adjacent to it. 1. Where the same stock or stocks of associated species occur within the exclusive economic zones of two or more coastal states, these states shall seek, either directly or through appropriate subregional or regional organizations, to agree upon the measures necessary to coordinate and ensure the conservation and development of such stocks without prejudice to the other provisions of this part. 2. Where the same stock or stocks of associated species occur both within the exclusive economic zone and in an area beyond and adjacent to the zone, the coastal state and the states fishing for such stocks in the adjacent area shall seek, either directly or through appropriate subregional or regional organizations, to agree upon the measures necessary for the conservation of these stocks in the adjacent area. Article 64. Highly migratory species. 1. The coastal state and other states whose nationals fish in the region for the highly migratory species listed in Annex I shall cooperate directly or through appropriate international organizations with a view to ensuring conservation and promoting the objective of optimum utilization of such species throughout the region, both within and beyond the exclusive economic zone. In regions for which no appropriate international organization exists, the coastal state and other states whose nationals harvest these species in the region shall cooperate to establish such an organization and participate in its work. 2. The provisions of paragraph 1 apply in addition to the other provisions of this part. Article 65. Marine mammals. Nothing in this part restricts the right of a coastal state or the competence of an international organization, as appropriate, to prohibit, limit or regulate the exploitation of marine mammals more strictly than provided for in this part. States shall cooperate with a view to the conservation of marine mammals and in the case of cetaceans shall in particular work through the appropriate international organizations for their conservation, management and study. Article 66. Anadromous stocks. 1. States in whose rivers anadromous stocks originate shall have the primary interest in and responsibility for such stocks. 2. The state of origin of anadromous stocks shall ensure their conservation by the establishment of appropriate regulatory measures for fishing in all waters landward of the outer limits of its exclusive economic zone and for fishing provided for in paragraph 3b. The state of origin may, after consultations with the other states referred to in paragraphs 3 and 4 fishing these stocks, establish total allowable catches for stocks originating in its rivers. 3. A. Fisheries for anadromous stocks shall be conducted only in waters landward of the outer limits of exclusive economic zones, except in cases where this provision would result in economic dislocation for a state other than the state of origin. With respect to such fishing beyond the outer limits of the exclusive economic zone, states concerned shall maintain consultations with a view to achieving agreement on terms and conditions of such fishing giving due regard to the conservation requirements and the needs of the state of origin in respect of these stocks. B. The state of origin shall cooperate in minimizing economic dislocation in such other states fishing these stocks, taking into account the normal catch and the mode of operations of such states, and all the areas in which such fishing has occurred. C. States referred to in subparagraph B, participating by agreement with the state of origin in measures to renew anadromous stocks, particularly by expenditures for that purpose, shall be given special consideration by the state of origin in the harvesting of stocks originating in its rivers. D. Enforcement of regulations regarding anadromous stocks beyond the exclusive economic zone shall be by agreement between the state of origin and the other states concerned. 4. In cases where anadromous stocks migrate into or through the waters landward of the outer limits of the exclusive economic zone of a state other than the state of origin, such state shall cooperate with the state of origin with regard to the conservation and management of such stocks. 5. The state of origin of anadromous stocks and other states fishing these stocks shall make arrangements for the implementation of the provisions of this article, where appropriate, through regional organizations. Article 67. Catadromous species. 1. A coastal state in whose waters catadromous species spend the greater part of their life cycle shall have responsibility for the management of these species and shall ensure the ingress and egress of migrating fish. 2. Harvesting of catadromous species shall be conducted only in waters landward of the outer limits of exclusive economic zones. When conducted in exclusive economic zones, harvesting shall be subject to this article and the other provisions of this convention concerning fishing in these zones. 3. In cases where catadromous fish migrate through the exclusive economic zone of another state, whether as juvenile or maturing fish, the management, including harvesting, of such fish shall be regulated by agreement between the state mentioned in paragraph 1 and the other state concerned. Such agreement shall ensure the rational management of the species and take into account the responsibilities of the state mentioned in paragraph 1 for the maintenance of these species. Article 68. Sedentary species. This part does not apply to sedentary species as defined in Article 77, paragraph 4. Article 69. Right of landlocked states. 1. Landlocked states shall have the right to participate, on an equitable basis, in the exploitation of an appropriate part of the surplus of the living resources of the exclusive economic zones of coastal states of the same subregion or region, taking into account the relevant economic and geographical circumstances of all the states concerned and in conformity with the provisions of this article and of Articles 61 and 62. 2. The terms and modalities of such participation shall be established by the state concerned through bilateral, subregional or regional agreements taking into account, inter alia, a. the need to avoid effects detrimental to fishing communities or fishing industries of the coastal state. b. The extent to which the landlocked state, in accordance with the provisions of this article, is participating or is entitled to participate under existing bilateral, subregional or regional agreements in the exploitation of living resources of the exclusive economic zones of other coastal states. c. The extent to which other landlocked states and geographically disadvantaged states are participating in the exploitation of the living resources of the exclusive economic zone of the coastal state and the consequent need to avoid a particular burden for any single coastal state or a part of it. d. The nutritional needs of the populations of the respective states. 3. When the harvesting capacity of a coastal state approaches a point which would enable it to harvest the entire allowable catch of the living resources in its exclusive economic zone, the coastal state and other states concerned shall cooperate in the establishment of equitable arrangements on a bilateral, subregional or regional basis to allow for participation of developing landlocked states of the same subregion or region in the exploitation of the living resources of the exclusive economic zones of coastal states of the subregion or region, as may be appropriate in the circumstances and on terms satisfactory to all parties. In the implementation of this provision the factors mentioned in paragraph 2 shall also be taken into account. 4. Developed landlocked states shall, under the provisions of this article, be entitled to participate in the exploitation of living resources only in the exclusive economic zones of developed coastal states of the same subregion or region having regard to the extent to which the coastal state, in giving access to other states to the living resources of its exclusive economic zone, has taken into account the need to minimize detrimental effects on fishing communities and economic dislocation in states whose nationals have habitually fished in the zone. 5. The above provisions are without prejudice to arrangements agreed upon in subregions or regions where the coastal states may grant to landlocked states of the same subregion or region equal or preferential rights for the exploitation of the living resources in the exclusive economic zones. Article 70. Right of geographically disadvantaged states. 1. Geographically disadvantaged states shall have the right to participate, on an equitable basis, in the exploitation of an appropriate part of the surplus of the living resources of the exclusive economic zones of coastal states of the same subregion or region, taking into account the relevant economic and geographical circumstances of all the states concerned and in conformity with the provisions of this article and of Articles 61 and 62. 2. For the purposes of this part, geographically disadvantaged states means coastal states, including states bordering enclosed or semi-enclosed seas, whose geographical situation makes them dependent upon the exploitation of the living resources of the exclusive economic zones of other states in the subregion or region for adequate supplies of fish for the nutritional purposes of their populations or parts thereof, and coastal states which can claim no exclusive economic zones of their own. 3. The terms and modalities of such participation shall be established by the states concerned through bilateral, subregional or regional agreements taking into account, inter alia, a. The need to avoid effects detrimental to fishing communities or fishing industries of the coastal state. b. The extent to which the geographically disadvantaged state, in accordance with the provisions of this article, is participating or is entitled to participate under existing bilateral, subregional or regional agreements in the exploitation of living resources of the exclusive economic zones of other coastal states. c. The extent to which other geographically disadvantaged states and landlocked states are participating in the exploitation of the living resources of the exclusive economic zone of the coastal state and the consequent need to avoid a particular burden for any single coastal state or a part of it. d. The nutritional needs of the populations of the respective states. 4. When the harvesting capacity of a coastal state approaches a point which would enable it to harvest the entire allowable catch of the living resources in its exclusive economic zone, the coastal state and other states concerned shall cooperate in the establishment of equitable arrangements on a bilateral, subregional or regional basis to allow for participation of developing geographically disadvantaged states of the same subregion or region in the exploitation of the living resources of the exclusive economic zones of coastal states of the subregion or region, as may be appropriate in the circumstances and on terms satisfactory to all parties. In the implementation of this provision the factors mentioned in paragraph 3 shall also be taken into account. 5. Developed geographically disadvantaged states shall, under the provisions of this article, be entitled to participate in the exploitation of living resources only in the exclusive economic zones of developed coastal states of the same subregion or region having regard to the extent to which the coastal state, in giving access to other states to the living resources of its exclusive economic zone, has taken into account the need to minimize detrimental effects on fishing communities and economic dislocation in states whose nationals have habitually fished in the zone. 6. The above provisions are without prejudice to arrangements agreed upon in subregions or regions where the coastal states may grant to geographically disadvantaged states of the same subregion or region equal or preferential rights for the exploitation of the living resources in the exclusive economic zones. Article 71. Non-applicability of Articles 69 and 70. The provisions of Articles 69 and 70 do not apply in the case of a coastal state whose economy is overwhelmingly dependent on the exploitation of the living resources of its exclusive economic zone. Article 72. Restrictions on transfer of rights. 1. Rights provided under Articles 69 and 70 to exploit living resources shall not be directly or indirectly transferred to third states or their nationals by lease or license, by establishing joint ventures or in any other manner which has the effect of such transfer unless otherwise agreed by the states concerned. 2. The foregoing provision does not preclude the states concerned from obtaining technical or financial assistance from third states or international organizations in order to facilitate the exercise of the rights pursuant to Articles 69 and 70, provided that it does not have the effect referred to in paragraph 1. Article 73. Enforcement of laws and regulations of the coastal state. 1. The coastal state may, in the exercise of its sovereign rights to explore, exploit, conserve and manage the living resources in the exclusive economic zone, take such measures, including boarding, inspection, arrest and judicial proceedings, as may be necessary to ensure compliance with the laws and regulations adopted by it in conformity with this convention. 2. Arrested vessels and their crews shall be promptly released upon the posting of reasonable bond or other security. 3. Coastal state penalties for violations of fisheries laws and regulations in the exclusive economic zone may not include imprisonment, in the absence of agreements to the contrary by the states concerned, or any other form of corporal punishment. 4. In cases of arrest or detention of foreign vessels the coastal state shall promptly notify the flag state, through appropriate channels, of the action taken and of any penalties subsequently imposed. Article 74. Delimitation of the exclusive economic zone. Between states with opposite or adjacent coasts. 1. The delimitation of the exclusive economic zone between states with opposite or adjacent coasts shall be effected by agreement on the basis of international law, as referred to in Article 38 of the Statute of the International Court of Justice, in order to achieve an equitable solution. 2. If no agreement can be reached within a reasonable period of time, the states concerned shall resort to the procedures provided for in Part 15. 3. Pending agreement is provided for in paragraph 1, the states concerned, in a spirit of understanding and cooperation, shall make every effort to enter into provisional arrangements of a practical nature and, during this transitional period, not to jeopardize or hamper the reaching of the final agreement. Such arrangements shall be without prejudice to the final delimitation. 4. Where there is an agreement in force between the states concerned, questions relating to the delimitation of the exclusive economic zone shall be determined in accordance with the provisions of that agreement. Article 75. Charts and lists of geographical coordinates. 1. Subject to this part, The outer limit lines of the exclusive economic zone and the lines of delimitation drawn in accordance with Article 74 shall be shown on charts of a scale or scales adequate for ascertaining their position. Where appropriate, lists of geographical coordinates of points, specifying the geodetic datum, may be substituted for such outer limit lines or lines of delimitation. 2. The coastal state shall give due publicity to such charts or lists of geographical coordinates and shall deposit a copy of each such chart or list with the Secretary-General of the United Nations. To be continued.